So, welcome and thank you for joining us today for a conversation about the patent system and the innovation economy with the Honorable Andrei Iancu, Undersecretary of Commerce for Intellectual Property and Director of the United States Patent and Trademark Office. My name is Adam Mossoff. I'm Senior Fellow and Chair of the Forum for Intellectual Property at the Hudson Institute, as well as co-chair of the Technology, Innovation, and Intellectual Property Program of the Classical Liberal Institute at NYU School of Law, both of which are co-sponsoring this event today. So welcome, Director Iancu, and I'm really looking forward to a fun and robust and interesting conversation.
Well, thank you, Adam. It's an honor to be here with you. Thanks for inviting me.
Great. Well, I'd like to just jump in right away. You've been director of the USPTO during a very tumultuous period in law and policy, and even more broadly in our society with the current COVID-19 crisis. And so I thought we should start our conversation today with some discussion about some foundational principles in law and policy, and then we'll use that as a platform then to talk about some applications to current events and issues in the law. So you're head of one of the very first agencies created by the federal government, what was originally known as the Patent Office before trademark registration was added to its many responsibilities in the 20th century. And issuing patents, in fact, has been a key function of the US federal government since 1790, since the very first Patent Act of 1790 was created by Congress. So how do you see the role of these property rights in the US innovation economy for the past 230 years?
Well, thank you for that question. It's a very broad and important question. I guess you're doing the whole interview in one question. But I appreciate the depth of the question, because the role of IP in the United States and in US history and the US economy goes back to the founding of this country, as you have mentioned. IP rights come from the US Constitution. As a matter of fact, the word right is mentioned in the Constitution only once, in the body of the Constitution itself, without the amendments. Only once, and it's in the Intellectual Property Clause. And it was that important to the founders. And the fact of the matter is that they were right. If you think back to the way the world was in the late 18th century, when this country was founded, you know, civilizations have been around forever, for a very long time. Humanity has been around for a very long time. We've had the ancient Greeks, the Mayans, the Romans, the Hebrews, the ancient Chinese. Throughout time, throughout history, throughout the world, and yet at the founding of this country, the state of the human condition was basically the same as it was in ancient Rome. If you had to go, if you had to send a message across town, you had to send Paul Revere by horseback, for example. Anesthesia was, you know, just a shot of whiskey. But that all has changed. So what happened in 1776? Did human beings all of a sudden just grow a second brain or something? Obviously, a lot of things changed, but it's my firm belief that the foundational change to human development from a technological point of view is the United States constitutional patent system, because it democratized invention for the first time in history. So with that background, there was an absolute explosion of innovation. For the first time, anyone could invent. You didn't have to be rich. You didn't have to be friends with the crown. In fact, you didn't even have to manufacture anything. And everybody did invent. And from a tiny country, it was just an upstart at that time, facing a huge empire, the British Empire. Within a century, we began to dominate the world in terms of technological advancement. And that has continued ever since. So we can get into more details, but the fact that the patent system was created to enable everyone and anyone to invent and own their inventions, it created an incredible growth, technological growth, and at the same time, economic growth.
Great. Yeah, that's a great framing for drilling down into some of the more specific details of how we achieve that. So, you know, a lot of people maintain that, well, the function of the patent system is simply to provide an incentive to invent, to spur the person in the lab or in the garage to come up with their invention, and then through the publication function, disclose that invention to the rest of the world. You mentioned in your opening remarks how patents led to an explosion, the patent system helped lead to an explosion in inventions, innovation, and economic growth. So is there an economic function to patents? Do they facilitate commercialization? Or is it really just about invention and disclosure?
Absolutely, it's all of that. So let me pick up on a couple of things that you said in your question and then get to the final point of your question. So patents play multiple roles. One is to incentivize innovation, and the other is to protect that invention. If you think about intellectual creations, before you think about them, they don't exist. It's not out there. You've created it yourself. But unlike a physical product that you might build on your land for everybody to see, you've created an idea, but it's in your head. You don't have to give it to anyone. You don't have to share it with anyone. You can keep it to yourself. You can keep it secret. And in fact, before the United States and our constitutional system, if you go back to the British Empire, they had this guild system with primarily dominated by secret guilds and trade secrets and the like, you know, the manufacturing, because you never knew what was happening behind those closed doors. So what the patent system does is, in addition to incentivizing just innovation, it incentivizes you to disclose. It gives you a reason and the comfort that you can disclose while being protected. So it's the incentive to innovate, and then it is the disclosure and publication of that is the ultimate genius of the patent system. Now, beyond that, it absolutely has a commercial, patents have commercial background. First of all, maybe you make the product yourself and you sell it and you feel comfortable doing that. So in and of itself, it enables your own commercialization, but then it enables others as well. It enables others to come to you to seek a license, so therefore and make it themselves, or frankly, to see what you have invented and for them to avoid it now that they know it, and then they can actually improve upon it. And that's how we build this exponential growth that we have had over the past couple hundred years, is improvement upon improvement. But from a patent commercialization point of view, in addition to you making it yourself or teaching others how to do it, the instrument also creates a trade, the patent creates a tradable economic instrument. Mm-hmm. So the ideas that originally were in your head now become a tradable economic instrument. And that creates all sorts of new opportunities.
Mm-hmm. Is this like a title deed and ideas? You now have a tradable instrument?
Yeah, yeah. So a lot of people analogize to deeds to land and the like. And there's a lot to be said for that. It's not a perfect analogy, but for sure, you know, you can trade deeds in land, and now you can trade, let's say, deeds in ideas to some extent.
That's a great phrase, deeds and ideas. The historian in me particularly finds that appealing. That you've touched on a lot of aspects of the U.S. Patent system as created under the U.S. Constitution, and so do you think any particular features of the U.S. patent system have been essential to its the recognition of it widely by many people as the gold standard patent system around the world. It's, you know, historically it's been referred to as a gold standard patent system relative to other countries. So what are, again, what are, you think are some of those features, those essential features that you think have given it that label in terms of supporting a growing U.S. innovation economy?
The U.S. patent system has been, and in my firm belief remains, the gold standards of patent system around the world. Several features. First of all, I think we were the first modern democratized patent system, so we have the longest history, the longest experience with it. Several characteristics to it. First of all, it does not discriminate. The system on its face does not discriminate between applicants. Anyone can come to the patent office and file an application. It does not discriminate between technologies. Every technology can apply, and the laws, at least theoretically, apply equally to all of them. We can get back to some of the more modern attempts to try to check some of that. But in any event, the concept that it applies equally to all people, all technologies, critically important. Quite a few other features, including low barriers to entry. It's always been the case in the United States that it doesn't cost a lot of money in the grand scheme of things to first apply in the first instance. It's very different from other major offices around the world. To this day, our application fees in the first instance are quite a bit lower. And beyond the patent office itself, the patent system in general in the United States has very strong and reliable enforcement provisions, at least as compared to the rest of the world. And you know, we historically have been a very reliable, have had a very reliable system to enforce patent rights as well as other IP rights, and we do not waver throughout history and throughout time. We can come back and talk a little bit about the current crisis, but this is a very good example. And right now, as we speak, our patent rights are as strong as ever in this crisis, and they need to remain that way. And we can talk about why. But so far in the United States, I'm very proud to say that there has been no wavering from the ability to enforce patent rights at all times.
Excuse me. Yes, and you know, it's interesting you're highlighting the democratization aspects of the U.S. patent system, something that economists and other historians have identified as some key attributes of what they've more generally abstracted away from, is that the U.S. approach has been to protect property rights and ideas as opposed to kind of personal privilege grants or regulatory entitlements that, you know, the Crown or the government might issue. That seems a rather kind of academic framing. You know, economists and historians in our books might want to talk about these issues. And so can you concretize that a little bit more, make it a little more real? You know, I think you've touched on it. You know, is it protecting something as a property right and an idea as property right? Is that what facilitates the ability to trade it in the economy and to prompt, you know, deliverance of these products and services into the hands of consumers?
Yes, I think that's right. And I think, look, there's a lot of debate as to whether these are property rights or not. I think we lawyers, and patent lawyers in particular, have the great ability to see a lot of gray in absolutely every question that's being presented to us, no matter how black and white it might be. I don't know why it's so difficult to come to the conclusion that intellectual property is property. The word property is in the title of the whole product to begin with. Of course, that's a simplistic view. But much more importantly, let's just look at the statute. The the patent statutes, 35 U.S.C., says expressly that patents shall have the attributes of personal property. And if you look at the traditional measures and yardsticks of what is property, when, you know, the right to exclude, the right to transfer, the right to use, the right to control, things like that, clearly apply to patents and other forms of intellectual property. And it's a critically important concept, as you said, Adam. It does not, once you have it, it does not depend on the favor of the crown or whoever else. It's yours. But beyond our statutes that actually expressly direct for this to be treated as personal property, just step back for a second and think about it fundamentally. You know, if you, as I mentioned at the very beginning, at bottom, these are rights given to concepts that did not exist before the inventor or the creator created them. I don't think folks have any difficulty agreeing with the fact that you have a piece of land. If it's yours, you put a fence around it, that's your property. I think everybody agrees with that. And in addition, if it is your property, you put a building on the property, or you do other improvements to the property, the fruits of your labor in your own land, I think people by and large will agree that is your property that you have created there from the land. If that all is true, how much more true is it for ideas? At least with land, it existed there beforehand, from memorial. You acquired it somehow, you're improving it somehow, but nevertheless, it began with nature. An idea simply does not exist on this planet until you have come up with it yourself. And you don't have to share it with anybody unless somebody says it is yours, it's your property, and we're protecting you for it, and you agree to voluntarily share it. So these are somewhat philosophical underpinnings to the what I long-standing view that at least in the United States, these rights have been treated as personal property rights. Now, the analogies, all these analogies are not perfect, and we know that there are cases from the Supreme Court and elsewhere that touch upon different aspects of all this as well. But you know, I think the fundamentals generally, I think there is general agreement with just the basic.
And you know, you mentioned, you know, it facilitates the sharing by saying, you know, you can share it, and now you can negotiate with other people on their terms. And you mentioned earlier that this is one of the kind of the key features of the U.S. approach, is that it allowed people to license, you know, which is something that a lot of people don't think about. Most people don't think about when they think about patents. Usually they think, oh, I get a patent and I then make the product. And people don't realize that, you know, a lot of great innovators that we all learn about in school, Thomas Edison and Charles Goodyear and Nikola Tesla, they licensed their innovations. They shared them in the way that you've been describing. And you mentioned licensing, as I mentioned already, but maybe we can talk about a little more detail. I mean, do you think patent licensing is important? And you know, what do you think is its contribution, patent licensing, to the U.S. innovation economy?
Yes, licensing is critically important, and it facilitates commercialization of the technology, which is ultimately what we need. Bring that technology to market. Let's take a simple example. Think about a university lab where lots of research goes on, but universities are not in the business of manufacturing. It would be a shame if all that work did not see the light of day in a commercial product available for sale on shelves in stores. So how do you get that out to market? And the answer is through, first of all, having IP protection for that technology, and then enabling the transfer of that technology. This example illustrates, in a fairly clear term, in the university context, how you can use IP and the licensing surrounding IP to transfer the technology from the lab to the market. Well, the same is true as between commercial companies as well. One company might invent something for whatever reason. They don't think they're in the business for making that product, but nevertheless, the invention exists. It would be a shame for society if you don't have a means of getting that out to market in another way, if it's desirable, if the market desires it. So by enabling folks to transfer that technology from one company to another, if anything, it helps, and it helps greatly to commercialize the product and advance the human condition. And just one more point with a concrete example, Adam. I thought, and I think, licensing is so important in the current pandemic. We created at the USPTO a portal called Patents for Partnership, where folks can list their patents and patent applications, published applications, list them as available for licensing if they're related to COVID-19, so that others who are interested can look at it and can seek out a license or whatnot. It can enable sometimes small inventors, smaller companies, federal research labs, government entities, universities, whoever, who don't have a means of getting that technology created, especially fast as we need it now in the current pandemic. Maybe somebody else can see it and actually offer a manufacturing platform. So that's just one example in the current situation.
Well, it's a fantastic illustration of the power of licensing and this division of labor that you talked about, where people can share information between each other and facilitate even greater efficiencies in the distribution of products and services. It's interesting you mentioned, that you started talking about the COVID-19 pandemic and the crisis that we've been in, because there's been a debate about patents in this context. Sometimes one hears that, patents are characterized as a blockade on progress. And sometimes they're referred to as a tax on innovation. Do you think, and one has heard this in the current policy debates about COVID-19, do you think this is an appropriate framing of how patents function in the innovation economy?
No, and I am keenly aware of the suggestion by some that patents can act, you say, blockade or barrier to innovation. The fact, here's the bottom line fact: I don't think there is any evidence for that, and I ask anyone who's making the argument, these are important times right now. We're in a moment of national and international crisis when it comes to this global pandemic. We have to be very careful when it comes to innovation and the protection of innovation, because it can make big differences to the human condition, and I can explain that in a few minutes. So before folks make some accusations about intellectual property acting as a barrier to innovation or to access to treatments or the like in the current pandemic, we need to see evidence. Please put forward the evidence. As far as I know, there is no such evidence. In fact, the evidence at the moment is to the contrary, that the various IP owners in the space are collaborating with each others and with others nationally and internationally more than ever. There are private licensing deals that are being done across the world in a variety of ways, and all the evidence suggests that that the market system for intellectual property rights is working very well. Here's what we need to be very careful about in these debates. The reason we can even talk about a vaccine, for example, in just a matter of months for something this complicated is because there's been so much technological development to date, so much investment, so much innovation that's taken place prior to the pandemic. And it doesn't just apply to vaccines, it applies to treatments, it applies to the PPE that everybody's using. And frankly, it applies to this electronic platform that we're conversing on. So much innovation that's gone on before the crisis. What we do in a crisis will have impact not just on this crisis, but on future crises. If we don't send a strong message that your IP rights are protected when they're actually needed, then inventors and investors will not be incentivized and will not feel comfortable making the investments necessary to create the innovations needed for the next crisis down the line that we cannot anticipate right now, when and what it will be. IP rights must be respected at all times, and especially when they are needed. I am very thankful that in the United States so far, it's not even a question. IP rights across the board in the US are firmly secured. We are leading the international discussion to make sure that IP rights are secured and that the IP experts are always at the table when discussions about these issues are taking place, whether it's in the domestic or international public policy debate. Of course, there needs to be a balance. Like with everything in IP, you need balance. Of course, we need to keep a firm eye on questions of access and the like. And if we see the need, any government needs to maintain the flexibilities necessary to address abuses or the like. But before we do anything like that, I would ask for evidence-based solutions.
Excellent. Before we drill down into some more specific kind of topics of policy concern and legal debate at the moment, I'd like to maybe frame one more general question and as we build out our platform of discussion here, from philosophy to property to intellectual property. And that is, commentators and academics and even lawyers oftentimes and policymakers often distinguish between the high-tech industry on the one hand and the biopharmaceutical sector on the other, when it comes to not just innovation policy, but patent policy. And so one often hears, commentators sometimes say, well, you don't need patents in the high-tech industry because of the fast innovation cycle and low R&D. And they contrast this sometimes against the biopharmaceutical sector, where you have billions of dollars in R&D over long time spans, as you were just, I think, referencing. We were talking about how we will be impacting the future responses to pandemics if we weaken patents today. And of course, there are some differences in the technology. I don't need to make light of that, and there are differences in business models. But do you think that it's true that high tech is always low R&D and fast innovation cycles, and biopharma is always long innovation cycles and high R&D? I mean, or are there more similarities between these different sectors in the innovation economy than sometimes people talk about?
Look, I don't think it's easy to generalize and describe broad-based labels. The world is not as simple as, you have bio and tech for several reasons. First of all, there are a whole host of technology innovations that are very difficult and complex and long-term. Think about artificial intelligence. Think about autonomous vehicles. Look how long it's taking for us to bring autonomous vehicles to market for many reasons, but including the technology. It's very complicated to figure all that out. And so many other things. And then there are obviously on the biopharma sides, even though they are usually complex, but sometimes not. Sometimes they can do things very quickly in a matter of months. So, you know, I'm leery to segregate technologies that way. Plus, here's another very important point. There's a lot of convergence in today's world, Adam. You know, one of the reasons there is such a huge explosion in in biotechnology in the recent years is because science and technology have merged, have converged. There's great advances in our scientific understanding of the biology. At the same time, there are huge advances in computing speeds and technologies. And now these are being combined. So we see a lot of patents, a lot of IP and innovation that in the biotech, for example, that has both complex computational algorithms of DNA sequences, for example. Okay, what kind of a patent is that? Is that a bio patent, or is that a software or a tech patent? Very often you're going to have in the same claim elements to both. So, you know, there are all sorts of arguments out there that because the needs and the fields are so different in the various areas over time, maybe we should have two different systems or two different approaches or different sets of laws, one for bio, one for tech, or some other way of cutting these things. I think that is, I just don't think it's workable. In the example I gave, if you do have two systems, where are you going to put that biotech patent in? Which system are you going to be in? Beyond that, technology changes all the time. Different areas come up and different areas disappear. We can't keep creating new systems or modifying the systems based on a specific technology. I think it's really important to have one IP system, one patent system that works across the board. Makes it a bit complicated sometimes for the reasons you mentioned. But hey, we live in a complicated world.
Yeah, it's a great way to kind of tie back into your earlier comments about the the technology neutral and owner neutral aspects of the patent system as being a key feature of its gold standard status of what's made it so successful.
Yeah, absolutely right. I mean, there's so many other issues as well. You have to think about international aspects as well. You know, if you start creating different approaches, different laws, or different systems for different technologies, well, then what's to stop some other countries picking different technologies than we have to ascribe special status or special laws to them? So it really has been a long-standing feature of the US patent system that we are technology neutral, and I think it's got to be that way.
So you mentioned the current crisis that is on everyone's mind in every respect, including why we're having this conversation over an internet platform system, which is the the COVID-19 pandemic that is continuing. And you talked about the tremendous response to the COVID-19 pandemic by the biopharmaceutical industry and how this was facilitated by the investments that were made possible through the having reliable and effective property rights in their innovations, facilitating communication and licensing and things of this sort. Now, but before the pandemic, there has been some concern among stakeholders in the innovation economy about the ability of innovators in the biopharmaceutical space to secure patents in their innovations. A lot of focus has been on the the Section 101 and the patent eligibility jurisprudence that's been developed by the U.S. Supreme Court over the past 10 years, or starting about 10 years ago, and has been continuing in lower courts and at your agency in the past 6 or 7 years. And there was a recent case decision, as I've heard you mention, and we've been talking about, the American Axle decision at the Federal Circuit, where Federal Circuit held that a method of making an automobile axle, a kind of classic 19th century technology, is an unpatentable abstract idea, which raises a lot of concerns by people even outside the biopharmaceutical space. But a lot of focus has been on the biopharmaceutical space. So, can you comment on some of these concerns that have been expressed and raised, and how have you in the USPTO responded to this?
Yeah, so you've heard me say before, Adam, that when it comes to the current state of patent law in the United States, I think Section 101, patentable subject matter, remains the most important issue that still needs to be resolved here. I think we've made tremendous progress. I think we're closer to resolution now than we've been in quite some time. But nevertheless, concerns remain. I don't want to comment on any specific current case, especially cases that might still be percolating through the system. But look at a high level. Let me just say this. Everything that we do as humans is based on nature. We're part of nature, and our work is to harness nature for human and other types of uses. So the whole point of the IP system is to give protection to human endeavor to harness nature for practical purposes. Almost every invention, almost every technological invention, engineering creation is based on nature. We can't do anything else since we are nature ourselves, we live in nature. So we have to be very careful before we say things like we should not give patents on things that are based, in quotes, based on nature, because we risk swallowing up all of patent law. Mm-hmm. And the Supreme Court has expressly warned against such broad and sweeping statements that can inadvertently swallow all of patent law. Now, I don't think we are there, but certain statements can be taken out of context and generalized, and we just have to be very vigilant about that. Now, the fact of the matter remains that in the courts, the results of a Section 101 analysis in the lower courts, the results of a Section 101 analysis remains unpredictable to some extent. We at the Patent Office decided that we just can't go on like that. I just selfishly speaking, as the head of the Patent Office right now, when you're a lawyer in private practice, you have a client or a few clients, you can advise on a case-by-case basis. The courts can, see a number of cases, but still one at a time and so on. At the U.S. Patent Office, we receive 650,000 patent applications a year. We issue about 350,000 patents a year. We have 9,000 examiners that have every single day have to go through this statutory analysis. So the status quo ante 2 years ago was unsustainable for us as a system at the at the Patent Office. So we decided to create a new framework of analysis. We can't make new law, so we didn't. We basically just took all of the cases from the Supreme Court, the Federal Circuit, whatever, and we synthesized them. And we created an analytical framework for analysis under Section 101 for our examiners and the applicants who come before them. And it's now about 1.5 years in, and it's worked great, really beyond all expectations. Our examiners get the framework, they understand it makes sense to them. The applicants get it, it makes sense to them. Everybody that I have spoken with has indicated to me and to others that the approach that we have promulgated 1 year ago, the framework is working very well for the application process in the PTO. Now, those are anecdotal stories, but I wanted to see from a statistical, systematic point of view if we actually have moved the needle. So I had, we had a report generated just a few weeks ago, maybe a couple of months now, by the USPTO's chief economist that looks at all the relevant data on 101 from the PTO, and his conclusions were in line with the anecdotal evidence. Our guidelines have resulted in a decrease of uncertainty on 101 examination of 44%. A 44% decrease in just a year that he measured. Keep in mind that there's still a learning curve for examiners and the like under the new framework. Nevertheless, within just 1 year, a 44% decrease in uncertainty of examination. And that is simply by synthesizing the law and having a systematic approach. Now, this is the way we're doing it at the PTO. Hopefully, this is the way we're going to keep doing it. But the courts are independent, as they should be. I'm a firm believer in the independence of the courts. They don't have to follow our guidance, and they're not following our guidance. 1.5 years in, they have the same approach that they've had for quite some time. So there is still some of that uncertainty in the courts, although I have seen quite a bit of improvement there as well in terms of some predictability. But it would be helpful, to be frank, if the courts would also have, doesn't have to be our analytical, there are other options without changing the law, just the structure of analysis. Identify what is the subject matter that's excluded. Just tell people what is the subject matter that's excluded, and things like that. And I think it's doable, and it would be tremendously helpful. And if the courts did that, we could stop talking about the subject. We would be done. Now, if they don't, there's also Congress. There's some had been some activity in Congress last year on this issue. I haven't seen further activity this year, but that's still an option as well. All I can say, Adam, is that from the PTO's point of view, what we have done seems to have worked very well.
Excellent. It's excellent to hear. Thank you for that report. I hadn't heard that statistic before, so that's really great news. So shifting gears a little from patent eligibility, I want to ask you about the joint policy statement that was issued last December in 2019 between the USPTO, joining with the Antitrust Division of the U.S. Department of Justice and the National Institute of Standards and Technology, NIST, regarding remedies for infringement of patents on standardized technologies, what we patent lawyers and wonks call standard essential patents, which are subject to a commitment by patent owners who participate at standard development organizations that they license them on FRAND rates, FRAND, fair, reasonable, and non-discriminatory. The 2019 statement rescinded and replaced an earlier statement that was joined only at that time by the U.S. Department of Justice and USPTO in 2012. Now, what prompted the USPTO, the DOJ, and NIST to issue this new 2019 statement? Was it changes in law, new information, or both? And what was ultimately the goal that you saw that was thought to be achieved by this?
Well, look, ultimately, what we want to achieve for the entirety of the IP system, but this includes standard essential patents, is a balanced system that incentivizes and promotes innovation, and in particular, American innovation. Since the 2013 statement, the three agencies, became increasingly concerned that that statement was misinterpreted and misapplied, such that almost a presumption, so to speak, or de facto result was that injunctions and the like were simply stated to be unavailable for standard essential patents. We thought that that unbalances the system and creates perverse incentives. We issued a statement to correct that, because the end result, remember, I always say that IP is just a tool. IP is a tool to further increase innovation in the United States. It's really important for the US economy to have American companies in the United States working on standards-based technologies, and having strong IP rights when it comes to standard-based technologies in the United States would be, just like with other areas of technology, is critically important to incentivize and further increase the innovation in that space. So that's what ultimately motivated us to issue this statement, to correct the misinterpretation of the the misapplication of the 2013 statement.
Mm-hmm.
Basic position of the new statement that we issued in 2019 is a rejection of a special set of rules that limits remedies for infringement of standard essential patents subject to a FRAND commitment. As I like to say, standard essential patents are patents. All available remedies should be available to them, including injunctions, if appropriate under the facts and circumstances of that particular case. The other major point we wanted to communicate is that we want to encourage good faith negotiations in the FRAND for standard essential patents, and the transfer of that technology as between the patent owners and the implementers as appropriate. And we were concerned that having categorical positions on one side or the other, categorical positions such as injunctions are never available. We were concerned that this creates perverse incentives and that might lead away from good faith negotiations. So we wanted to make sure, and the statement does explicitly call for all parties to those transactions to negotiate in good faith.
Excellent, excellent. So we're coming up to the close of our discussion, so just a couple more questions. So I'd like to shift to discussing some of the institutional design issues at the USPTO, specifically with respect to the Patent Trial and Appeal Board, the PTAB, which began operations in 2012, which has been a source of legal and policy debate over the past 8 years. And over the past several years in your capacity as director at the USPTO, you've implemented many reforms at the PTAB in both its operations and even in its institutional structure, such as adopting the Phillips standard for claim construction. Now, I recognize you can't comment on any current dispute or particular case, but could you discuss these reforms a little bit and what you've heard from stakeholders about the impact on them?
Sure. Restoring balance to the Patent Trial and Appeal Board, the PTAB, was one of the major goals for me when I first came in. I spoke about that publicly from the very beginning. What I believe for actions at the PTAB, what I believe for the patent system in general, and in fact, all IP systems, whether it's copyright, trademark, whatever, is that you must have appropriate balance. There needs to be balance between the IP owners and the implementers. There needs to be balance between the technology areas. There needs to be balance between big companies, small companies, plaintiffs, defendants, licensors, licensees. And of course, in the instance of post-grant proceedings at the PTAB, there needs to be balance between the petitioners and the patent owners. So when I first came in, I didn't think that the PTAB system was within the appropriate bounds of balance. We've taken a number of reforms to restore that balance, and I think they've been very successful. You've mentioned one that we did very early on, which is the change of the claim construction standard. It's a very good example. It made no sense that the scope of what you of your patent depended on which tribunal you happened to be in, whether it was the courts or the PTAB. So we unified that claim construction standard, and I think there's broad-based acceptance that that was a good result. We have also done a number of other things, such as a much more robust amendment process, which was called for by the statute, by the way, and that's working fairly well, even though it's still fairly early days for that. The other thing that we have done is to make sure that IPRs are, and by the way, for folks new to this, an IPR is an inter-parties review, which is a form of a post-grant review that can take place at the patent office with respect to an issued patent. But the purpose of the IPR system was to create a faster, cheaper alternative to district court litigation. That was the stated purpose. And at the same time, Congress wanted to make sure that while they do create this new proceeding, that there are not multiple bites at the apple. So look, in the ensuing years after the statute was implemented in 2012, there were a number of people who had seen and identified loopholes in the statute and frankly abused it. And we've worked systematically in the past few years to close those loopholes. So, okay, you can bring a petition, but don't bring multiple petitions one after another. So we've basically eliminated what's called serial petitions. At some point, as Congress recognized when the statute was implemented in 2012, at some point, the patent owner is entitled to quiet title to that patent. We've drastically reduced parallel petitions. So that's the number of petitions that can be filed at the same time. You know, you wouldn't expect in a court of appeals, for example, to file multiple appeals at the same time. Excuse me, Your Honors, I have to file 7 appellate briefs on this one case. It doesn't even cross your mind. Why is it that you should be filing 7 IPRs on one patent? So we drastically reduced that as well. Mm-hmm. And we have also reduced the instance of having an IPR if the district court is very far ahead of us. Again, an IPR was meant to be a faster, cheaper alternative to district court litigation. But if the district court has already gotten to the end result before we can get to it, or will soon get to it, for sure, then we're not going to be faster because we're going to finish afterwards. We're not going to be cheaper because the expenses are done in the district court or almost done. We're just going to be an addition. And we're certainly not an alternative to the district court because their proceedings have finished or are about to finish. So in those circumstances, which by the way are fairly rare, but nevertheless, in those circumstances, the complete purpose of the IPR system is defeated. And the only thing that's left is that we have a second bite at the apple. Well, that destabilizes the patent system at large, and it reduces the confidence of the public in the system overall. So that's why we took action to reduce those instances. There's long-standing understanding in American jurisprudence that you should not get to repeated challenges against or based on the same issues, whatever the forum. Obviously, there are exceptions to that, but when we know that the district court has already come to a result or is about to come to a result, and all we can do is finish well afterwards, then it doesn't make sense to have a second bite at the apple when there is no benefit to have a faster or a cheaper system. So we've taken action with respect to that as well. In the end, I believe that the PTAB needs to act with restraint and humility and perform the duties that we are charged to perform, to issue and maintain strong patents, but at the same time, to make sure that there are no multiple bites at the apple and that the system is kept within balance.
Thank you. And you mentioned IPR, and which has been the primary focal point, I think, of a lot of the discussions about the PTAB. But there's another program at the PTAB that has recently come back into prominence, and the Covered Business Method program. It's set to end on very shortly now, on September 16th in 2020, pursuant to the sunset provision in the original American Invents Act of 2011 that created the PTAB. Now, some policy organizations and commentators have called for the CBM program to be renewed, and some have even called for it to be become permanent, like IPR. And what do you think about this? Do you think the CBM should be allowed to sunset? And what were some of the reasons why it was allowed to sunset perhaps in the AIA, kind of setting the framework for our understanding of these discussions today?
Well, the CBM was actually called a transitional covered business method program. It was transitional because it was meant to last only a few years during a transitionary period, and then sunset, as you indicate. It's supposed to sunset on September 16th. Yes, I believe it should be allowed to sunset. It's as it was originally agreed to, and it served its purpose. And now it can safely sunset. You know, there are very few CBMs filed nowadays. You know, at the very beginning we had 100 or more a year. Now we're down. This year, I believe we're at about a dozen at best. So it's really not a very popular program. Put that in perspective. We have well over 1,000 IPR petitions a year, and here we're talking, you know, 1% of that. And so it's not a very popular system anyway, program anyway. But beyond that, it's inherently problematic in that it isolates a particular area of technology. And as we've been discussing throughout this program, Adam, as a general principle, it's not good, and it's not in the tradition of the American patent system to isolate for whatever purpose a particular area of technology. So it should be allowed to sunset. It's been the PTO's long-standing position that it should sunset. Even the prior administration issued a public statement that it should be allowed to sunset, and that was something like 4 years ago. And for those petitioners who still need to come to the patent office for a post-grant review, IPRs and PGRs are still available. And of course, ex parte re-examination is always available as well. So people still have plenty of avenues available to come back for review at the PTO.
Well, great. Coming up kind of on the end of our time, so I'd like to sneak in one more question if you have time for this, which is in many of your talks over the years, you often highlight inventions and innovators and the role of their patent inventions, not only in their lives individually, but in society more generally. I mean, it's been a hallmark of your talks. You typically start with a story of an inventor, sometimes famous, sometimes not as well known, but should be. Why do you do this?
Yes, Adam, I feel very strongly about this. From the very beginning of my tenure here at the PTO, I talk a lot about inventors. In fact, Adam, you might have noticed we changed the look and feel of our website. If you go to uspto.gov, in the very top third portion of the page, every month we've added a story of innovation. We call it Journeys of Innovation. And that is for exactly that purpose, because we want to highlight these great inventors. You know, American history is just filled with remarkable stories of inventors, and as you say, some famous, some less famous, but they all have the fundamental characteristics which I believe are actually fundamental American traits: hard work, taking risk, perseverance, daring to go where nobody else has gone before or probably would not go, and ultimately overcoming tremendous odds to succeed. Invention is the story of America. I believe it is the American character, and it is an inspiration. And for the United States right now, for so many reasons, it is critically important that all Americans across demographics, across the geography of the United States, know about our history of innovation so that they are inspired themselves to participate. I want to make sure that kids can look up to these folks and see themselves in them. I want the little boy in places like, let's say, Atlanta, Georgia, to say, I want to be like Lonnie Johnson when I grow up. Lonnie Johnson is one of the most prolific, currently living African-American inventors with more than 100 patents to his name. I want a little girl to look up to somebody like Frances Arnold and say, I want to be like her when I grow up. Frances Arnold recently won the Nobel Prize in Chemistry, the first American woman to win the Nobel Prize in Chemistry, a Hall of Fame inventor with dozens of patents to her name. I want people to know about these stories so that they are inspired by them and they can emulate them. If we do nothing else, inspiring the next generation of inventors, I think will have a tremendous positive impact on the United States.
Well, excellent. That's I think, a wonderful note to end our conversation on. which has ranged from the heights of philosophy down to the nature details of particular institutions and doctrines to actually the key and I think part of how the patent system has played in the great American experiment and American exceptionalism. So thank you for everything that you have done as director of the Patent Office and for this and for taking time out of your very busy schedule to have this conversation today.
Thank you, Adam. Great chatting with you today and always. And thank you for inviting me. It's been an honor.
Wonderful.